duplicative counts and
the gang constitution.
duplicative counts and the gang statute. And have you put Mr. Carlson on already to talk about 4D?
He can do it, or I can do it, Your Honor. So either one of us, I'll let him know, but I can also do it myself.
You might want to let him know. Mr. Smith, you'll check on Carlson and his availability as well as you check on Mr. Bernini's arrival. We'll go ahead and start off with the okay? All right, so, Mr. Farley, if you want to, Mr. Menez, if you want to go ahead and you have any argument as to the duplicative counts?
Yes, Your Honor.
All right, go right ahead.
All right. Good afternoon, Your Honor. I mainly rely on Meeks v. State, which is 309 Georgia App 855. That held that a one count of theft by taking was subject to a special demurrer because it was entirely duplicative of another charge that was charged in the same offense. And here, Your Honor, I'm basically asking the court to apply Meeks to this indictment the way it's specifically written. In Meeks, the Georgia Court of Appeals held that the counts were duplicative because they provided no additional facts by which it can be distinguished from the other count, and it alleges neither a different set of facts nor a different date. And so, Your Honor, that's what I allege, that counts 50 and 51 are duplicative of count 49. Count 49 is where Mr. Farley is alleged, along with Mr. Stillwell, Nichols, and Garlington, to have murdered Mr. Drinks. And in that count, they say, the reason why, Your Honor, this is especially duplicative is it says that Mr. Drinks was an associate of a rival gang. So essentially what I'm asking the court here is to find it duplicative, because I know the state's going to say that a gang activity charge and a murder charge are not duplicative, even if it's that murder that is the basis of the gang charge. But, Your Honor, I think that this can't survive a demurrer under Meeks because they write up count 49 as a gang charge. They just don't write the caption. And, Your Honor, the caption is not what holds, it's the substance. And so here in count 49, the substance is the same as counts 50 and 51. Had they not put in that part where it says an associate of a rival gang, then I get it. There's an extra set of facts that, oh, we're saying you killed this guy, and then in this other count, we're saying you killed him as part of gang activity. But 49 says an associate of a rival gang. So because they wrote that in there, and they didn't have to, that's not part of the malice murder statute by any means, but they chose to allege it that way. And so within the four corners of this indictment, of which Mr. Farley is entitled to an indictment perfect in substance and form, here it's duplicative. Had they not put that, it wouldn't be duplicative. But what I submit to the state, what different fact is alleged in counts 50 and 51 that's not alleged in count 49? Because in count 49, they say it's an associate of a rival gang. So if you say someone has an associate in a rival gang, by inference, you're saying that that person is in a gang. And essentially, count 49 alleges Mr. Farley to be in a gang, and it alleges that the person killed was a rival of the gang that Mr. Farley is supposedly in. So count 50 and count 51 that allege the criminal street gang activity with the murder of Mr. Drinks as the subject matter, Your Honor, those are both duplicative of count 49 because they included count 49 as gang activity. So looking within the four corners of the substance of these three counts, there's nothing different in count 51 or 50 that we don't already have in count 49.
That it?
For that motion, yes, Judge.
Okay, talk to me about the unconstitutionality of the gang statute.
Sure, Judge. So,
And you understand the Supreme Court already considered that issue, right?
I understand, Your Honor. I don't think the Supreme Court's going to consider anything with regards to Mr. Farley because there won't be a conviction, but just out of caution, I do think maybe the United States Supreme Court or possibly some other court might review this, Judge. So I do... Right.
Yeah, but what's your good faith basis to challenge?
Yeah, I can explain that, Judge. The good faith basis is that Rule 418 in combination with the Georgia gang statute just completely flies in the face of the most fundamental aspect of our government, which is checks and balances between the three branches. We have Your Honor representing the judicial branch, we have the state representing the executive branch, and we have myself and the other attorneys representing individuals and people in the state of Georgia. And so how it's supposed to work is that we're supposed to be checking each other, we're supposed to be balancing each other. But what we have here is, Your Honor, Rule 418 just completely circumventing Rule 404B and rendering 404B meaningless and robbing both the people of the state of Georgia and the judicial branches of the state of Georgia of any sort of check on the authority of the state to circumvent the legislature, who's elected by the people of Georgia to write the statutes, who wrote 404B. And, Your Honor, under 404B, as the court knows, other acts are not allowed in for propensity. They're only allowed in for limited purposes like intent, motive, absence of mistake.
Wouldn't you agree that it's a different statute promulgated for a different reason?
Exactly, Judge. And what's the huge problem here is that our grand jury proceedings are entirely secret. They're not transcribed. And there is no mechanism for either the people of Georgia or the jurists of Georgia to check the state to stop them from doing what this leaves open to be done. So, for example, which is, Your Honor, they might in bad faith, let's say we have a murder case, and that person accused of murder has an aggravated assault, but there is no other way to introduce that except for propensity. So the judge would say, as the state would know, that, I'm denying your 404B, this is propensity, that's not allowed. Our legislature does not allow propensity. However, 418 does allow propensity. And that's what makes the gang statute and rule in combination with Rule 418 so unconstitutional under the United States Constitution. Because what's to stop the state in a secret, untranscribed grand jury proceeding in bad faith just throw on a gang charge onto the murder charge, then... Right, Your Honor, but there's no one to check them. They're doing it in secret, and it's untranscribed, so there's no one to hold them accountable. We have rules, but without enforcement and accountability, the rule is meaningless. And so 418, in combination with the Georgia gang statute, has made 404B meaningless because all they have to do is throw a gang charge on there in violation of the rules of ethics, which happens from time to time, and they can choose to violate that behind closed doors, untranscribed, and then they can throw up their hands at the end of the trial and say, oh, the directed verdict got granted. We didn't know that was going to happen, wink, wink, but they did know. And the reason they did it and put it on there, even though they knew it would be dismissed by directed verdict, is that so then they can use 418 instead of 404B and then bring in, for example, a past aggravated assault for propensity, which is exactly what the legislature didn't want the state to ever be allowed to do. And so there is no... Right, Your Honor, but if we didn't have the gang statute, then we couldn't accuse someone of gang activity, and then we couldn't apply 418. We would have to apply 404B, and we wouldn't be talking about propensity. But
Evidence of the court, as you know, under law.
Judge, I can't hear you in the back.
So you understand that evidence under our evidence code, Title 24, may be used sometimes for differing purposes, right? So, right?
yes, Judge.
So under the gang statute in 418, it's a little different than 404B and the other purposes for which evidence is admitted, right?
Yes.
Okay, all right.
And that's just exactly, it is the existence of that, Your Honor, that I find to be just totally unconstitutional because now there is no way to do checks and balances. It's just whatever the state wants.
The legislature wrote the gang, or enacted the gang statute and they enacted 418, right?
Yes.
So they obviously had knowledge of 404B, correct?
Yes.
All right. So, I understand your argument. Is there anything else you wanna put forth?
No, Judge,
Okay.
I just ask you to grant that, and then the state can appeal something for once instead of us, appealing everything.
Okay, all right. Ms. Rosenwasser? Any other motions? I think I've dealt with the other, only one is the 418, and I'm waiting on Mr. Carlson.
Yes, Judge. The only other thing I have that I failed to mention is I did have an amended discovery motion that the state's mostly accommodated, but there's one aspect they're not accommodating that I'd like the court to
What is that?
compel them. They relatively recently, sent out these gang profiles on each of the defendants, and then nowhere in the discovery does it say who wrote those profiles and when they were written. And their written response to my motion says, well, you can just call the law enforcement witnesses. But that's exactly why I need Your Honor to compel them to tell me which law enforcement witness produced which gang profiles and when, because even though the state might try to say that's not exculpatory, the discovery statute says it's not only exculpatory things that they have to give us, but anything that might lead to something exculpatory. So the way they've described this gang profile of Mr. Farley, I think they wrote that up after this case already started, and if that's the case, that definitely impacts, my absolute theory of innocence.
Have you had any conversations with Ms. Rosenwasser or Mr. Smith or anybody else in regards to this issue?
No, Judge, only just through our written responses to the
And
motion.
why don't you have a conversation with her about that? Madam, or is it that are you all willing to, or can you give him that particular information?
Your Honor, I don't want to speak out of turn. I would just request Mr. Farley contact the trial team. I would request Mr. Farley contact the trial team leaders to get an answer on that. I do not want to speak out of turn without confirming with them. If he'd come up to me about this earlier, I could have relayed that message and received an answer.
Okay. So why don't you have a conversation with Ms. Love or Ms. Hilton, and then if it continues to be an issue, I'll certainly deal with that. Okay?
Yes, Judge.
Hold on. We got Mr. Carlson here who can talk about 418. Do you want to go ahead and finish your 418 argument, sir, and then I can let Mr. Carlson respond to that?
No, Your Honor. Just to perfect the record, I also challenged the gang statute for violating freedom of speech and freedom of association, but I don't have further argument about that. I just have it in my motion. Everything I object to about 418, I've already said to the court.
All right, Mr. Johnson?
Yes, Your Honor. On behalf of Mr. Eppinger, I wanted to join in Mr. Menendez's motion.
David, if you ever listen to Mr. Harvey, I hate to cite to him all the time. I hate to cite to him all the time. But he did you all such a solid. He said, look, unless you opt out, everybody else gets to opt in, right?
Well, yes, Your Honor.
Okay, so add to it.
Oh, man, added specifically as it relates to Mr. Eppinger.
Okay, so let's take care of that.
Oh, yes, Your Honor.
But if you start replicating, I'm gonna cut you off. All right?
Your Honor, the court is aware of Mr. Menendez's arguments.
Just heard it.
Just like to
And
say,
read the motion.
yes, Your Honor. As it
Okay.
relates to my client, Mr. Eppinger, we would contend that I believe it's counts. Let me find the exact one, Your Honor. I believe it's counts 38 and 39 of, no, I'm sorry, 28 and 29 of this matter, which charged my client with possession of a firearm by a first offender. The two counts are exactly written the exact same. They did not allege any different information whatsoever. And this counts 34 and 35, Your Honor. They allege that my client was in possession of a firearm on a particular date after having been convicted, placed on first offender for a particular crime. It is the same crime, the same date as listed in counts 34 and 35. There is no additional information required or added in this that would differentiate these two counts, Your Honor. So based on the similar arguments made before, we do believe that these counts are duplicative and should not be included in the indictment, Your Honor. Well, at least one of them should not. Thank you.
That it?
Yes, that's it, Your Honor.
Okay, all right. All right, Mr. Carlson, can you speak to Mr. Menendez and by implication the rest of the defendants who have specifically decided to opt out are seeking to have this court declare Georgia Rule of Evidence 418 unconstitutional. So if you would speak to that, I would appreciate it.
May it please the court, Your Honor?
Go ahead.
And if I may, Judge, approach the court reporter with my car.
You may.
Thank you.
Your Honor, again, Mike Carlson, Executive District Attorney on behalf of the state, responding to the constitutional challenge. I believe it's actually to 1615-4, the charging provision of Georgia's Street Gang Terrorism and Prevention Act, as well as Official Code of Georgia 24-4-418, which is an evidence code provision that exclusively applies to cases charged under OCGA 1615-4, and that is by language of the statute. So, Your Honor, let's take a look first at what we have here. These are essentially facial challenges to both of these statutes before the court. There's no acknowledgement in the briefing that at least has been reviewed by this Assistant District Attorney of the controlling or persuasive authority involved. And that begins with the fact of a presumption that a Georgia statute is constitutional, presumption that the challengers, the court knows, must rebut in cases like State versus Brannan, B-R-A-N-N-A-N, 267 Georgia 315, 267 Georgia 315, that's a 1996 case, sets forth. Also, in a facial challenge such as this, the opponents have to demonstrate that there is no set of facts under which the Gang Act or 1615-4 would be valid. A case for that out of the 11th Circuit is Benning versus Georgia, 391 Fed 3rd, 1299. 391 Fed 3rd, 1299. That's an 11th Circuit case from 2004. So accordingly, these challenges should be denied and the motion should be denied. Now let's take a look first at the challenge, which, and again, my apologies for not being here for all of the argument, but based on what I did hear and based on the briefing, is a First Amendment challenge. Well, that was dispensed with, Your Honor, by our Supreme Court in a 2009 decision, Rodriguez versus State. 284 Georgia 803, 284 Georgia 803. Now, Rodriguez was strictly a case under OCGA 1615-4A, that's Alpha, Judge, the primary charging provision of the Street Gang Act. But notably in Rodriguez, the court explained, and Justice, the late Justice's opinion affirming Judge Hancock of DeKalb County's decision, pointed out that the gang statute prosecutes conduct, not association and not expression. And I'll read a quote from the case. Criminal gang activity, quote, is not protected activity even when committed by a group exercising their constitutional right of free association, because, of course, there is no constitutional right to commit criminal gang activity. And when that criminal gang activity is committed by an individual who is a member or an associate of a criminal street gang and participates in the gang through the commission of that criminal gang activity, then the additional offense of a violation of 1615-4A can be brought. Now, there is a complaint here about 1615-4B. That is the commission of those offenses in order to increase or maintain status in the gang. Again, that is criminalizing behavior, not expression. So, as to the double jeopardy claim that we saw there, at the outset, let's direct the court and the record and opposing counsel to OCGA 16-15-4M as in Mary. That is a statutory non-merger provision that is housed within the Street Gang Act itself. And our Supreme Court and our Court of Appeals have specifically dealt with the issue of whether or not someone being charged with multiple subsections of the Street Gang Act and being sentenced and convicted, or convicted and sentenced for those subsections as well as the predicate offense, violates the Constitution. No merger, no violation in that case, Judge. And I want to take us first to the Court of Appeals case on that, Judge, which is Nolly versus the state, wherein the specific quote is that in Nolly, let me actually, before I get to the quote, the defendant was charged with more subsections than any of the defendants here were. And that was actually, there was an A, B, D, and E violation in addition to the underlying predicate. And the courts there said in Nolly from the Court of Appeals, and I'll have that citation to you in a second, Your Honor, from my co-counsel.